Imagine you've been living with someone for 5 years, 10 years, 15 years, or even more. You've built a home together, raised children, and even bought land. And one day, things fall apart. Are you married in the eyes of the law? In this video, we'll be breaking down what exactly is the presumption of marriage, how was the presumption of marriage interpreted before, how is the presumption of marriage interpreted now, and what are the practical implications of this new approach. So what exactly is the presumption of marriage? This is when the courts infer the existence of a marriage when a couple has not yet formally registered their union. Basically, the court is saying that you might not have gotten a formal wedding, but based on how you lived and conducted yourself, we will presume that a marriage existed. So how was the presumption of marriage interpreted before? To explain this, I'll use the case of Yahweh versus public trustee. So in this case, we have a man named Yahweh who was originally from Uganda but lived in Nairobi and worked as a pilot at the East African Airways Corporation. He died in 1972 without leaving a will. Upon his death, Wanjiku, the appellant, reported this to the public trustee, who is responsible for handling estates when someone dies without a will. So she claimed that she was his widow and they had lived together and had 4 children. As the public trustee began administering the estate, claimants from Uganda disputed her status, claiming that she was not married to the deceased. Evidence showed that Wanjiku and Yahweh had lived together for 9 years until his death. So one of the legal issues the court had to determine was whether Wanjiku was married to the deceased, and specifically whether she was married according to Kikuyu customary law. Let's look at how this case moved through the courts. At the High Court, the judge found that Wanjiku had not proven the existence of a Kikuyu customary marriage. The court noted discrepancies in the witnesses' statements concerning traditional ceremonies like rurashio, and therefore concluded that no marriage existed between the parties, either under Kikuyu customary ceremony or at all. After the High Court decision, Wanjiku decided to appeal. Her lawyer noted that the judge had overlooked an important principle, the presumption of marriage that arises from long cohabitation. The Court of Appeal unanimously agreed to her appeal and declared that Wanjiku was indeed the deceased's wife, and therefore she was entitled to her share of inheritance alongside the other beneficiaries. The case established that the presumption of marriage arises from long cohabitation where a couple lives out as husband and wife, allowing the courts to infer a marriage for purposes like inheritance and property disputes. Furthermore, the presumption of marriage could only be rebutted by strong and weighty evidence to the contrary. Importantly, this presumption is just that, an assumption based on conduct, and does not automatically create a legally binding marriage in every situation. It provided a way for the courts to protect parties who had lived out as spouses even in the absence of marriage ceremonies. But over time, as society changed, the courts decided to tighten the rules, and that's where the new interpretation comes in. So how is the presumption of marriage interpreted now? Today, courts are more cautious. They don't easily presume the existence of a marriage unless certain legal ingredients are present. This shift in interpretation became especially clear after the landmark case of M&K versus POM and another. In this case, M&K, the appellant, and POM, the respondent, had lived together for many years, and the dispute was about who owned a piece of property they had both been using in Dagoretti. POM claimed that they had started living together as husband and wife in 1996, and that they had both bought and developed the property together using their joint savings. However, because the seller didn't want to sell to him since he was a Kisii, they decided to register the property in M&K's name instead. Over the years, they built rooms on the land, lived out in one, and rented out the others. POM even managed the utilities and even had a small bar there. But in 2011, their relationship fell apart. M&K sent him away, which is when POM went to court, claimed that he was her husband and that he deserved a share of the property. M&K denied everything. She said that they were never married, just friends, and that she had only allowed him to help manage the property. Furthermore, she claimed that she was already married under Kikuyu customary law to another man who had since passed away. So she couldn't have been married to POM, and the relationship was just an adulterous one. From these facts, the court had to tackle two legal questions. Firstly, to determine whether the Old Married Women Property Act of 1882, which governed how property was shared between married couples, could actually apply to people who are simply cohabiting and did not have a legally recognized marriage. And secondly, since this particular relationship was over, was there a fair way to divide the property between the parties? Now let's look at how this case moved through the courts. At the High Court, the case was dismissed. The judge acknowledged that the two had lived together for a long time, but M and K was already married to another man, KM, and therefore the relationship was an adulterous one, and POM could not rely on the Married Women Properties Act to claim a share of the property because there is no presumption of marriage since M and K was already married. POM wasn't satisfied with the decision and decided to appeal. He argued that the High Court was wrong to say that M and K was married to someone else and wrong to ignore the property that they had acquired together. The Court of Appeal agreed with him. It found no proof that KM even existed and went on to presume that a marriage existed between M&K and POM. The court then ordered that the property be divided equally, giving each of them a 50% share. M&K, unhappy with that 50-50 decision, decided to take the case to the Supreme Court. Initially, the Court of Appeal refused, arguing that the case was one of a private matter and not of general public importance. But later, the Supreme Court stepped in and allowed the appeal to proceed, saying that the matter went beyond just this couple and had a much wider impact on Kenyan family law. The Supreme Court brought this long battle to an end, and in doing so, reshaped how the Kenyan courts interpret the presumption of marriage today. The court partially allowed her appeal, holding that no presumption of marriage existed between M&K and POM. Even though they had lived together for many years, the court found that M&K was still legally married to KM during much of that period, and therefore she lacked the legal capacity to contract another marriage. Therefore, this cohabitation could not amount to a valid marriage. However, the court acknowledged that both parties had contributed to acquiring and developing the property in dispute. So to prevent unjust enrichment, M&K was granted 70% and POM 30% based on their respective contributions. Most importantly, the Supreme Court set out clear qualifications that must now be met before a court can presume that a marriage exists. The long cohabitation, but long cohabitation alone is no longer enough. Then you have legal capacity to marry, mutual intention and consent. This means there must be clear evidence that both individuals genuinely intended and consented to the marriage-like relationship. Courts will no longer impose marriage where the parties themselves did not intend it, and then the couple must have presented themselves to family, friends, and society as husband and wife. Even when these conditions appear to be met, the presumption can still be overturned by strong, distinct, and convincing evidence to the contrary. Through this case, the Supreme Court made it clear that Kenyan courts will now approach the presumption of marriage with greater caution. This decision therefore encourages individuals to define their relationships financially and legally with clarity, minimizing risk when it comes to separation. Speaking of property, in the next video we'll be diving into how marital property is divided after divorce. So if you love this breakdown, make sure you leave a comment, subscribe, share, and let me know what you think about the Supreme Court decision and how it will shape the future of cohabitation in Kenya.